This is the OFM Business Hour. Olebogeng here. Now, towards the end of February 2023, the Financial Action Task Force placed South Africa on its dreaded grey list over shortcomings in tackling illicit financial flows, a move that scars the country's international reputation and may raise costs for banks and asset managers. Now, prior to the grey listing, a need to tighten up the country's regulatory frameworks led to the promulgation, in haste of course during December 2022, of the new General Laws, Anti-Money Laundering and Combating Terrorism Financing Amendment Act 22 of 2022. What is this Amendment Act, and how will it impact other pieces of legislation and, most importantly, your business? Tonight on the show, I'm in conversation with Luhann Prinsloo. He's a director in the Commercial Practice Group at PH Attorneys Sandton office. PH Attorneys used to be known as Patswani Henny. Here is my sit down with him in which he answers some of those questions. Before we get into the new legislation the country has introduced in countering money laundering as per the concerns of the Financial Action Task Force, let's start with what legislation existed in the country beforehand to counter terrorism and money laundering, and what holes were identified in said legislation, or was it more a case of a lack of enforcement rather than legislative holes per se? A very lengthy question. But, you know.
I'll try and keep it concise. Prior to the enactment of the General Laws, Anti-Money Laundering and Combating Terrorism Financing Amendment Act, if it's fine with you, I think I'll just call it Amendment Act going forward. South Africa has had several pieces of legislation in place to counter terrorism and money laundering. Now, those include, amongst others, the Prevention of Organised Crime Act, the Financial Intelligence Centre Act, the Prevention and Combating of Corrupt Activities Act, and the Protection of Constitutional Democracy Against Terrorist and Related Activities Act. A key criticism levied by the Financial Action Task Force, or the FATF, against South Africa was a poor track record in identifying, investigating and convicting money laundering and terrorist financing crimes. They noted the increasing levels of financial crime, with specific mention also of increasing levels of corruption and state capture within government institutions. The report concluded that South Africa has a solid legal framework for combating money laundering, but that significant shortcomings remain. In particular, they found that the country needs to pursue money laundering and terrorist financing in line with its risk profile, including by proactively seeking international cooperation, detecting and seizing illicit cash flows, and through greater policing by financial institutions and improving the availability of beneficial ownership information. Further to their findings, they identified several areas of concern with regard to South Africa's anti-money laundering and counter-terrorist financing regime, including inadequate customer due diligence measures, weakness in the legal framework, in that it affected our ability to investigate, prosecute, and sanction money laundering and terrorist financing. They identified a lack of effective supervision by our accountable institutions, particularly in relation to the compliance with customer due diligence requirements, and insufficient international cooperation. Thus, some of the answer to your question, it's clear that South Africa's existing legislation provides a framework for combating money laundering. However, the report identified weaknesses in the implementation and enforcement of these laws. Therefore, it's not only a lack of enforcement that's the issue, but also legislative and regulatory gaps and deficiencies that needed to be addressed.
Well, can South Africa have the grey listing reviewed? And if so, is there a time limit, and what needs to be done to have the country removed from the list?
Well, the length of time a country remains on the grey list depends on the speed in which it resolves the identified shortcomings. On average, it takes anywhere from 1 to 5 years for countries to address the deficiencies and to be taken off the list. Something that will only occur after a final on-site assessment when both the FATF and the relevant country believe that all elements of the action plan have been largely or fully addressed. Importantly, it can be done much sooner, with other countries having been successful in as short as 2 years. From the 67 recommended actions identified by the FATF, South Africa has addressed all but 8 strategic deficiencies, which we are expected to address by no later than the end of January 2025. However, government does hope to address them sooner, possibly early on in 2024. Government will, however, need to report back to the FATF on a regular basis on the progress it has made, which will create an opportunity on set intervals to have the country's grey listing reviewed by the FATF. At current date, there is, as per the FATF's website, no set date for another mutual evaluation or reassessment.
Luhann, can you provide us with a brief overview of what changes have been introduced in the new General Laws, Anti-Money Laundering and Combating Terrorism Financing Amendment Act? You said you'd refer to it in our interview as the Amendment Act. And briefly weigh in on what other pieces of legislation it will impact.
Certainly. I'm glad you've just realized that as long as that name is, so too is the list of changes by the Amendment Act and the number of existing statutes that have been amended. Now, some of the statutes that have been amended include the Trust Property Control Act, the Companies Act, the Financial Intelligence Centre Act, the Non-Profit Organisations Act, and the Financial Sector Regulation Act. Of particular relevance are the amendments to the Trust Property Control Act and the Companies Act, which now require a number of additional compliance steps to be taken by trustees of trusts and companies on a regular basis, and that will affect virtually every single trust and company in South Africa, with non-compliance resulting in fines and possible imprisonment in the case of trustees, and business restrictions in the case of companies.
That's the knowledgeable Luhann Prinsloo. He's a director in the Commercial Practice Group at PH Attorneys Sandton office. PH Attorneys used to be known as Phatswane Henny. Part 2 of my sit down with him is on its way as he expands on why businesses need to take heed of these regulatory amendments. Welcome back to your daily dose of the OFM Business Hour. We're continuing to weigh in on the legislative changes that are being introduced to counter the Financial Action Task Force's grey listing of South Africa. Here is part 2 of my sit down with expert Luhann Prinsloo. He's a director in the Commercial Practice Group at PH Attorneys Sandton office. They were previously known as Phatswane Henny. Why is it important for business owners to be aware of these amendments or to be conscious of them?
Well, companies remain a popular vehicle for conducting business in South Africa. Trusts have also been a mainstay and are often utilized as an estate planning vehicle and to also hold shares in companies. As stated earlier, there are several additional compliance steps to be taken by trustees and companies. The problem with trusts is that they can be used to conceal the true ownership and control of assets, or can be used to channel illicit funds in a way that makes it difficult for authorities to effectively determine ownership and control of the trust, as well as to trace the source and the flow of the funds to or from individuals that may be connected to criminal activities. The same rings true when one considers companies. I mean, you only need to watch a movie or a series about drug trafficking, terrorism, or even cyber hackers to associate criminal activities with the use of a shelf company or so-called offshore companies. And by looking at the amendments, it's safe to assume that our government definitely believes the company to be a vehicle abused for illicit criminal operations and transactions. Now, in the case of trusts, one can summarize the new compliance requirements as them requiring trustees to document and record the beneficial ownership structure of the trust. Now, this is the ultimate warm bodies that control the trust and that stand to benefit from its assets and income. They should also lodge that with the Master of the High Court and keep records of any engagement with accountable institutions of the trust up to date. Failure to do so will attract hefty fines and the possibility of jail time for trustees, making non-compliance no light matter. Importantly, though, it doesn't mean that trusts are no longer valid or not allowed to be used to hold shares or for estate planning or other authorized purposes. It must just be understood that a trust has become a target for attention by anti-money laundering authorities who require increasing transparency and reporting from trusts to ensure that it is not being used for illicit activities. In the case of companies, there is a new obligation to record beneficial ownership structures of the company, once again being the natural person who owns and or has some form of control over the company, as well as to include the securities register of the company in the annual returns to be submitted to the Companies and Intellectual Property Commission, or the CIPC. To date, it has not been a requirement that the CIPC should receive the securities register of a company lodging their annual returns. And companies who fail to lodge the same now run the risk of business restrictions. Company directors, shareholders, and officers should thus take note of these changes to ensure that they are compliant and prepared to correctly maintain and submit the necessary information to the CIPC. For business owners, understanding the new legislation, especially the new definitions built in dealing with beneficial ownership and the accompanying administrative duties and reporting requirements, can be rather complex. It is important for business owners to be aware of the changes and to take the appropriate steps to ensure they are compliant. Those who do not comply, in the case of trusts, for example, expose themselves to fines up to 10 million rand and possible imprisonment of up to 5 years, or both. In the case of companies, if they fail to correctly disclose the required information with their annual returns to the CIPC, you're looking at possible business restrictions, your company's business status being amended by the CIPC from in business to deregistration process, and of course being non-compliant with the Companies Act, all of which may cause serious damage to a company's reputation, brand, and ability to do business.
Thank you so much, Luhann. Where can people get more information on the aforementioned Amendment Act? We understand PH is also conducting a series of webinars on the subject matter. Tell us more.
Yes, I'm pleased to tell you that we had our first one yesterday, which was very successful and insightful for the public. And PH attorneys will also be conducting a series of webinars on the Amendment Act, which will provide more detailed information on the changes introduced by the Amendment Act and their implications for businesses. In addition to these webinars, people can also get more information on our website. That's phinc.co.za, and they can also follow us on all of our social media platforms.
That wraps up my conversation with Luhann Prinsloo from PH Attorneys. You can re-listen to it under the business section on OFM.co.za. Also keep an eye out for those webinars that PH will be having on the subject matter.